Thanks, Alistair. I think when I undertook to give this paper, I was probably somewhat distant from the memory of how much is involved in actually organising a conference. But in any event, I felt it was very important for two reasons. One is because the paper that I'm going to give today builds upon another paper which the Society's Secretariat has produced, and I've been very ably assisted in that endeavour by Henry Davis, one of our research fellows. And the other is because I feel that in my tenure as Executive Director, and indeed in the 5 years of my involvement with the Society before I was appointed Executive Director, that I have, like so many others, benefited immensely from the incredible generosity of Ian Callanan, who was a wonderful president and a very great mentor. In the tradition of John Stone, I want to leave a very good amount of time for questions and discussion following my remarks. So I'm going to give a sort of truncated view of the paper because I do hope that you will all have some interesting thoughts to share and some questions to ask. In October 1987, Sir Harry Gibbs, having earlier that year concluded his term as Australia's 8th Chief Justice, delivered a lecture entitled The Appointment and Removal of Judges as the third in the annual Menzies Lecture Series at the University of Virginia. Only a few years later, Sir Harry would agree to become the inaugural president of the Samuel Griffith Society, a position he would occupy until his death in June 2005. John Stone, in his tribute for Sir Harry following his death, explained that Sir Harry had been chosen by the founders of the Society for this role as our inaugural president because he was, quote, the outstanding judicial exponent of a federal, i.e. an anti-centralist viewpoint in Australia at the time. With reference to Sir Harry's reasons in the Australian Assistance Plan case, in Kuata and in the Tasmanian Dams case, John further explained that by this he meant that Sir Harry, quote, respected the fundamentally federal nature of Australia's constitutional arrangements and was distrustful of the creeping concentration of constitutional power in Canberra. Sir Harry Gibbs is, of course, not the subject of this paper, but in beginning, as I have done by referring to Sir Harry, I hope to do two things. The first part of this paper seeks to build upon the lecture given by Sir Harry in 1987, to which I've just referred, by exploring the current system of judicial appointments in Australia, its virtues, and the risks inherent in proposals to reform this system that have been modelled upon reforms adopted or proposed in other jurisdictions internationally. The second part of this paper pays tribute to the Honourable Ian David Francis Callanan, AC, KC, who last year retired as the Society's third and longest-serving president after a tenure of 14 years. Just as Sir Harry Gibbs was, quote, the outstanding judicial exponent of federalism in his time, Justice Callanan was, and remains, one of the leading federalist judges of our times. It is, therefore, obvious why the Society sought him out to be Sir Harry's successor as its president. By exploring some of the qualities exemplified by Mr. Callanan before, during, and after his tenure on the High Court, I aim today and in this paper to identify some of the key qualities that a future government tasked with appointing a new judge to the High Court of Australia may be well served to seek out. The Samuel Griffith Society is now an important part of a hugely significant tradition in the Australian legal profession, from Sir Samuel Griffith to Sir Owen Dixon to Sir Harry Gibbs to Ian Callanan. But what of the next Justice Callanan? How ought he or she be identified and appointed? This paper seeks to answer these important questions as it pays tribute to one of the greatest judges, exemplifying the greatest fidelity to the Constitution of the Commonwealth of Australia and its federalist purpose in our nation's history. Traditionally, the appointment of judges in common law jurisdictions has been a function performed by the Crown. This practice has its foundations in the 12th century reforms under King Henry II, which culminated in the Magna Carta of 1215. Clause 45 of the Magna Carta guarantees that the Crown will not appoint justices except from such as know the law of the kingdom and are willing to keep it well. This development marked the beginning of the establishment of a separate legally qualified judiciary drawn from qualified legal practitioners. But I want to repeat the second part of that clause. Those who know the law of the kingdom and are willing to keep it well. When Sir Harry delivered his Menzies lecture in 1987, it remained the case that judicial appointments were made by the executive government alone in Australia, Great Britain, Canada and New Zealand. In fact, the lone exception in the common law world to this system of appointments was that in the United States, the advice and consent process of the Senate. While much of the world has changed in the last 40 years, this system remains largely unchanged in Australia today. And there's a good reason for that. It has served us well. In terms of formal requirements, there are few. Section 72, Roman 1 of the Constitution provides that justices of the High Court of Australia and other Chapter 3 courts shall be appointed by the Governor-General in Council. In practice, this means that judicial appointments are a function of the executive government and the cabinet process. The same is generally true of the states, in which appointments are made by the Governor and Council, i.e. they are made on the advice of the government of the day. The only other formal requirement imposed by Section 72 of the Constitution is the one introduced as a result of the 1977 referendum imposing a mandatory retirement age for all federal judges, that no person shall be appointed a judge if they have reached the age of 70 years. Turning specifically to the High Court, the High Court of Australia Act 1979 provides two things. First, Section 6 provides that where there is a vacancy in an office of justice, the Attorney-General shall, before an appointment is made to the vacant office, consult with the Attorneys-General of the states in relation to the appointment. Secondly, Section 7 of the Act provides a person shall not be appointed unless he or she has been a judge or a legal practitioner for not less than 5 years. There is a clear link between this second provision concerning the qualification of justices and Clause 45 of the Magna Carta, and this is a subject to which I will return. Although not defined in the Act, the requirement that the Attorney-General consult with state counterparts has a clear federalist purpose. This purpose was articulated during second reading debate by the Leader of the House, the Honourable Ian Viner, who was a member of the Western Australian Bar prior to his election as the member for Stirling, who stated that, quote, "This provision should do much to ensure that the court continues to be truly national in character and fully equipped to discharge its constitutional functions as a federal Supreme Court." And this is the second subject to which I will return. In practice, the process by which federal judges are appointed in Australia is one of incredibly broad private consultation with not only state counterparts and cabinet colleagues, but also with members of the judiciary, the legal profession as a whole, and other key stakeholders and members of the wider community. And this is a very important process, which I'll speak more about in a moment. But first, I want to turn to one of the main proposals for reform to this system and some of the reasons why I think it is incumbent on us to ensure that it is not adopted. Other jurisdictions internationally employ a variety of other methods for the selection of judges. Some examples include appointment by the executive on the recommendation of an independent selection committee, selection committees comprised of bureaucrats or other representatives of some combination of the three branches of government who themselves select judges, election by the legislature, or indeed, in some jurisdictions, even direct election. In 2006, the United Kingdom moved to an independent selection committee model with the introduction of a Judicial Appointments Commission. The Commission mainly acts, quote, as an independent body that selects candidates for judicial office in courts and tribunals in England and Wales, and for some tribunals with UK-wide jurisdiction. The Commission is comprised of 15 members drawn from the judiciary, the legal profession, and non-legally qualified lay members. Its duties are, quote, to select candidates solely on merit, to select only people of good character, and to have regard to the need to encourage diversity in the range of persons available for judicial selection. It seems to me that there may be a tension between the first and the third of those duties, but that's not the primary focus of my paper today. In 2022, the Australian Law Reform Commission handed down a report into, quote, judicial impartiality and the law of bias. In what some might view as an example of mission creep, the Commission made, quote, a suite of recommendations addressing judicial appointments, judicial education, ethical guidance, the collection of feedback and data, and accessible information about the courts. While the Commission stopped short of calling for the introduction of an equivalent to the UK's Judicial Appointments Commission, it did recommend that the government adopt, quote, a more transparent process for the appointment of federal judicial officers, and that at a minimum requires a call for expressions of interest, the publication of selection criteria, and a commitment to promoting diversity without compromising the principle of merit-based selection. The ALRC also called on the government to commit to the collection and reporting of statistics on judicial diversity. You may recall that the Samuel Griffith Society was the only organisation to make a submission that advocated for the position that the current system of judicial appointments should be retained, and that merit alone ought to be the only criterion upon which judicial appointments are made. We were the only organisation, the only submission to this ALRC inquiry to advocate for the retention of the current system of judicial appointments and to advocate for the position that merit, competence, should be the only criterion upon which judges should be appointed. The current system of judicial appointments serves our system exceptionally well. The great strength of the current system is that it allows for broad, yet discreet, consultation with a wide range of relevant stakeholders. This process of quiet consultation ensures that the government of the day can comprehensively consider the largest pool of potential candidates while preserving their discretion without any risk of unnecessary personal or professional embarrassment. Any move to a public expression of interest process or a public selection panel process would risk jeopardising the greatest strength of the existing appointment system. Furthermore, the current system has also ensured that judicial appointments in Australia have remained overwhelmingly apolitical. In contrast, systems involving higher levels of public scrutiny of prospective judicial appointees, such as the United States, have become increasingly more politicised. Our system works well because it incorporates the principle of responsible democratic government, involving the broadest range of ministers who are responsible to the Parliament and therefore to the people. It is not a process that is inherently captured by bureaucrats, technocrats, experts, or the profession. And this is because sitting around a cabinet table, every minister has input into the decision. Any move to take that power away from Cabinet and give it to unelected bureaucrats or a judicial commission, I think would be a grave mistake. And part of the reason that I think it would be a grave mistake is that I think it would encourage the appointment of only certain kinds of individuals with an increasingly narrower professional background and lived experience. And this is where I want to turn to Ian Callanan. Ian David Francis Callanan was born on the 1st of September 1937 in the small town of Casino in the Northern Rivers region of New South Wales. Sitting on the banks of the Richmond River, just south of the Queensland border, Casino is 716 kilometres north of Sydney, but only 228 kilometres south of Brisbane. So it's perhaps unsurprising then that less than a week after his birth, a young Ian Callanan moved with his family to Brisbane. And he has remained a true Queenslander in every sense ever since. While I will not attempt, in the limited time that I have, to do what others, such as Nicholas Hasluck, who we'll hear from later this afternoon, and Amanda, who's spoken just now, have done so eloquently before, I will make brief reference to several biographical details which I believe demonstrate some of the attributes that made Ian Callanan such a formidable and exemplary judge. And I should say here as well, I chose the session title, The Quintessential Judge Today, not to mean that in any way Mr Callanan was the average judge, but rather that he is the exemplar judge that we should look to emulate. Having obtained a Bachelor of Laws at the University of Queensland while simultaneously undertaking articles, Mr Callanan was admitted to practice in 1960 and signed the bar roll very shortly thereafter in 1965 after 5 years in practice as a solicitor, during which time he became a partner in the firm of Conwell and Company. At the bar, Mr Callanan developed a broad national practice, which is increasingly rare today to see, appearing in high-profile cases concerning almost every area of law, from complex commercial and industrial relations disputes to defamation and criminal trials, including at the time the longest-running defamation trial in Australian history, and of course many significant constitutional cases in the High Court. In developing this practice, he quickly earned a formidable reputation and soon held retainers from some of Australia's largest corporations, including some of our most influential banks and media companies. I'll come back to this broad professional background in a moment and why I think it is both unique and made Mr Callanan well placed to perform his function as a judge on the High Court in a moment. Mr Callanan was appointed Queen's Counsel in 1978. He was President of the Queensland Bar Association between 1984 and 1987 and President of the Australian Bar Association between 1984 and 1985. Famously, he was briefed by the Commonwealth DPP to prosecute Lionel Murphy, at the time a sitting High Court Justice, to appear in extradition proceedings against Christopher Skase in both Australian courts and Spanish courts, and to prosecute the first bottom of the harbour tax fraud case, which was appealed later to the High Court. So you can see from just those very brief vignettes the true breadth of Mr Callanan's practice and the experience from which he was subsequently able to draw on the court. Mr Callanan is the last person to have been appointed to the High Court directly from private practice at the bar. At the time of his appointment in 1998, it had been more than 22 years since the last direct appointment from private practice to the bar at the bar to the High Court. However, this was not always so. Prior to the appointment of Sir George Rich in 1913, of the 8 people appointed to the High Court of Australia, only Sir Samuel Griffith had prior judicial experience. Of the 57 people appointed to serve on the High Court in its 122-year history, 42% have had no prior judicial experience, and many were drawn, particularly in our earlier years, from amongst Australia's foremost advocates at the bar. There have been periods in Australian history, and I believe that we now are in one of those periods, where the members of the High Court have had a more narrow range of prior experience professionally and have been drawn from a narrower geographic pool. Currently, a majority of 4 of the current justices on the High Court are from Sydney. Of those not from Sydney, 2 of the remaining 3 are from Melbourne. And so this means that for the first time since 2007, there is only a single judge on the High Court who does not reside in Sydney or Melbourne. In fact, not until before the appointment of Sir Harry Gibbs in 1970 has the court represented a narrower pool of the Australian legal profession and our federation. This is to say nothing for the fact that there has never been a South Australian or a Tasmanian appointed to the High Court, and there have been, of course, very few Western Australians appointed. I don't believe that this is because there are not suitable practitioners in Western Australia, South Australia and Tasmania for appointment, but I do believe that on occasion there has been a dominance of the legal profession from Sydney in particular, and I argue, and I'm sure that many of you might agree, that Australia is a federation and that we're benefited from a broad range of perspectives. And perhaps some of the things that Amanda spoke about in her paper may have been decided differently if a broader and more federalist composition of the court existed. The final and most important attribute of Justice Callanan that I wish to draw attention to is that of his unwavering fidelity to the Constitution and its true federalist purpose. But fidelity is nothing without courage. As has been highlighted by Amanda, Justice Callanan consistently demonstrated a preparedness to do what he believed was right, even when this meant that he was alone. And let's not forget, it was 5 years on the court before Justice Callanan was joined by Justice Hayden, who we'll hear from this afternoon. But the role that Justice Callanan performed, particularly in some of the very famous and important dissents, such as that in Work Choices, which Amanda explored very thoroughly, is incredibly important. It's important because he has blazed a trail for others to follow, others who have the same unwavering fidelity to the Constitution and to the law as written, not as they might wish it to have been written, and a courage to articulate those views not only in private but also, importantly, in public forums. And so I think if I can draw some of these threads together, in looking for future potential appointees to the High Court or indeed to other intermediate courts across Australia, future governments would be well served to look beyond the patterns that have in recent times emerged and to draw from a broader range of experience, particularly experience in a broad range of areas of law, in private practice, in managing a practice, as Mr. Callanan did, and in also a broader range of geographic representation that would, I think, further the federalist intention of our framers. But most importantly, those tasked with the solemn responsibility of advising our viceregal representatives on the appointment of judges should look for courage and a fidelity to the Constitution and the rule of law. And so I think now we have some time for questions.
Thank you, Xavier. I'll go straight to Stuart Wood.
I promise this is not a pre-arranged Dorothy Dixer, so no, I'm looking forward to what Stuart has to ask.
I just remember reading this, and it's really a question for you, Alistair, as well as Xavier. This is a extract of a speech of Dyson Hayden to dinner of the New South Wales Bar and Bench at the time that Ian Callanan was on the High Court. And he says as follows: "The High Court is said to have a problem of geographic balance. 5 New South Welshmen, 1 Victorian, 1 Queenslander. The actual position is quite different. First, Justice Hayne is not a Victorian. He was born in Gympie, Queensland, a matter obvious from his entire style and demeanour. Secondly, Justice Callanan is not a Queenslander at all, but a true New South Welshman, born in the fine town of Casino. So a geographic balance of 6 New South Welshmen and 1 Queenslander is much more satisfactory and more nearly approaching perfection." You may well have been at that dinner, Alistair. That is a view from the Sydney Bar, that everyone on the High Court should come from Sydney, and one can understand that. And I don't want to deal with the various criticisms that are made of the various bars, but merely to point out that if one has lived a whole life in Sydney, then we're all product of our own circumstances. And it's simply impossible to have a feeling for the federal nature of the Constitution when you are born, lived, educated, worked in Sydney. It's very, very difficult to do that. And you can see from Richard Court's speech last night his passion for the essential federal nature of the Constitution. Ian Callanan, really a Queenslander, had the same innate feeling. Isn't it the case, really, Alistair and Xavier, that the more perfect or something approaching perfection would have no barristers from Sydney on the High Court?
I'll let Alistair have the first right of reply, and then I'll give myself the opportunity to speak without, with having heard his contribution.
Well, I think Dyson's comments were purely based on merit and not greater diversity. But I think Xavier's made a very good point, which is that people from New South Wales essentially think that they are the centre of Australia, and unless they travel outside of New South Wales, they don't know how much other people have a contrary view. So I think the notion that by having greater federal diversity on the court, you will get a move away from centralisation in terms of decision-making that will result in centralisation of power in Canberra, I think is a very strong argument, and I would tend to agree with that. And it would encourage, I think, going now to Amanda's paper, a greater concentration on the original intention of the Constitution rather than ever-increasing centralisation of power in Canberra.
So a few points. First, I certainly don't advocate that there be no people from Sydney or New South Wales appointed to the High Court. And I certainly also don't advocate that there should be some geographic quota on the court. I don't think that either of those things would be advantageous. I also should say two things. I don't wish to verbal Justice Hayden, but I understand his true position is that merit should be the only criterion, and certainly that's a position that I fully support. But I do think that Ian Callanan is a Queenslander, and I think 4 days, as I understand it was, in New South Wales, albeit in the great town of Casino, does not make him a New South Welshman. But to the substantive question, and obviously I think it's evident from my thesis, I think the point of geographic diversity is twofold. One, certainly there is, I think, going to be different views, or there will be different views amongst people from different parts of Australia about federalism and how a federation works and should work. So in furtherance of the federalist purpose of the Constitution, I think that having some geographic diversity is important. But secondly and separately, I think practitioners in Western Australia have a very different experience, have very different clients, and engage in some ways different legal problems than practitioners in Sydney, for instance. And I think it's very important. It goes to one of the other points that I made in the paper, which is that one of the things that made Ian Callanan a great appointment to the High Court was that he had, in representing the range of clients that I alluded to and some of the biggest corporations in Australia, had a real appreciation for what the law is really all about, which is that the courts exist as a forum for mediating and resolving disputes. And so at the forefront of all of that has got to be the parties. And it's important, I think, for judges to recognise that and to recognise why people come to court and the disputes, what the disputes are about. Because the role of a judge is not to sort of act as a Platonian philosopher king making pronouncements about moral issues. It's to resolve controversies that come before them with reference to the interests of the parties. And I think often that's forgotten. I think particularly as in countries in Europe and internationally, this sort of concept of judges as a sort of profession, in some ways maybe a sort of club, has emerged and has grown in popularity here. I think that's been forgotten, that the point of the system is to help people, businesses, to resolve disputes so they can go back to doing what they are there to do. So I think that's the other reason why geographic diversity is important, because, as I say, I mean, Western Australian practitioners will have a different experience.
I may regret this, but Jeffrey Phillips.
Just, there's a microphone, Jeff.
Thank you. Either of you can answer this question. What do you think of Paul Keating's dictum that if you're not living in Sydney, you're just camping out?
Well, I might take this one, Alistair, but I think anyone who had been with us last night in the Ritz-Carlton or stayed overnight or indeed is going to be with us this evening would have a few things to say about camping out, because this is a fantastic venue, and I think that well, anyway, I'm not going to criticise Sydney, but in any event,
Jeffrey didn't disappoint. Jim Allen.
So if you think Sydney is sort of the centre of the world in Australian terms, in Canada, I'm from Toronto, and the basic view is that there is no Canada outside of Toronto. But I'm interested because our Constitution makes all sorts of federalist bargains, the same number of senators per state, and you just dismissed the idea that you would put into the Constitution some sort of judicial balance. So in Canada, the Constitution says 3 out of 9 Supreme Court judges from Quebec, and then by convention, never broken, 3 from Ontario, which would be equivalent to giving Melbourne a third, Sydney a third, and then the other 3, one goes to the Atlantic provinces, which a smaller share of the population than Tasmania. British Columbia gets 1, and the Prairie provinces get 1. That's never been broken. Trudeau tried to break it about 12 years ago, and it was like an insurrection, and he backed down. And so although the Canadian judges have completely and totally lost their minds on all rights-related issues, on federalism, one of the things that keeps them sort of on the track is because the small provinces are guaranteed top judges. And so I don't know why you just dismiss it out of hand.
Well, it's a great point, and I have to say Canada is streets ahead of Australia in terms of federalism. I think well, quite possibly, Jim, but certainly, indisputably, Canada, I think the Canadian courts get a lot of things wrong, particularly around rights, but in terms of federalism, they are excellent. But I do think, and this again comes to the first part of my paper, and why the two are related, I do think that the cabinet process acts as a means of achieving the same end without putting in something as rigid as a requirement. Now, yes, if someone were to propose an amendment to the Constitution and it were to receive popular support through the referendum process, that would be a fine way of putting in some sort of quota. I would look at that differently than some sort of political or legislative quota. But I do think that the retention of the current system, when it works as it should, helps achieve the same purpose, and that's my own preferred method of achieving what I'm talking about. Because I think when you have a federal cabinet, which includes people from all over the country, as it should, then my encouragement to members of those cabinets in the future should be that they should be raising some of these issues. They shouldn't accept, and I'm not suggesting that I have any insight into the internal deliberations of cabinet, but they shouldn't, in a hypothetical sense, accept necessarily the recommendations of the Attorney-General or the Attorney-General's Department uncritically. Those recommendations may be worthy, but I think that the Cabinet process allows for a robust consideration of all sorts of issues, including judicial appointments, and I think we're well served when that process plays out.
Sometimes there's more scrutiny than others. Can I just point out that with our three arms of government, I think Jim Allen makes a good point, which is that we have federal balance in terms of the composition of cabinet and in terms of the Senate, but we don't in the other arm of government, which is the judicial arm of government, principally our High Court under Chapter 3. There's a question over there.
We've talked about the cabinet process perhaps facilitating a greater sense of the federal compact and the balance that might be struck on the High Court. But I'm interested in asking you how we solve the problem in terms of appointment of judges of what might be described as availability bias, that there are people in the cabinet and an appointment comes up, and having been somewhat close to that process myself, it seems to me that there's often a rush to, well, who do we have, who's nearby? And I think it would be beneficial, given the nature of this society and the number of younger students who are here as well, if you could comment on how we solve that problem and ensure that there is a breadth of talent that is from across the Federation itself, so that we don't have a problem where it's not just Sydney, but it's people east of George Street in Sydney who are dominating the court.
I have a four-word answer to that question of how do we deal with availability bias in judicial appointments, and that is the Samuel Griffith Society. But to elaborate, I think I do look at the United States as an example, and I look at the Reagan administration and the development of a more robust and principled approach to judicial appointments that occurred even in that 8-year period and beyond. And I think that the way that we address that issue is that we have an open forum for discussion and debate, and we talk about issues such as interpretive philosophy, and that rather than trying to sort of hide these things, I think it's interesting, if I can diverge for a second, that the Chief Justice is reported to have made some comments last week at a conference here in Western Australia, effectively recanting a previous position that he had expressed about Sir Albert Piddington, and it having been inappropriate for Albert Piddington to have expressed views about his views about how he might approach consideration of issues relating to the division of powers between the Commonwealth and the states. And the Chief Justice expressed a view last week that he was wrong to have said 27 odd years ago that Piddington should not have expressed any views. I'm not sure I entirely agree, because I think that it's important that in the process of appointing judges that Cabinet does consider in an appropriate way. It's not a political issue. It's a matter of what people who we might appoint as judges view their role as being if they are appointed. And as I was saying before, is it their view that as a judge their role is to be a Platonian philosopher king who seeks to mould the law to accord with their own subjective view of morality, or is it their view, which is the view that Ian Callanan is exemplar of, that the role of a judge is to be faithful to the Constitution and to the law as it's written, not as they wish it were written?
Now, we're running out of time. I'm going to go with one quick question and answer, Xavier, here to this gentleman.
It's not quick.
Can you make it quick? You've got 30 seconds, James.
You better go there.
My name's Ian Warner from Western Australia. We've heard a lot of discussion about geographical representation. No one's even given any thought to the Northern Territory. Western Australia, our country, is separated from the eastern states by the Nullarbor Plain, which gives us a great degree of objectivity in anything we consider. So to me, one should really give consideration for a really good High Court to have all appointments coming from Western Australia, my country.
Well, I'll take that more of as a comment, but maybe if I can conclude on this note, I think that your point is well made, that Western Australians bring a very important perspective to the Federation. It's a perspective, I think, in the Federal Parliament that is more apparent. It's not necessarily as apparent in the profession, but I hope that as part of this discussion we might, over time, make it more apparent. I do think, though, with respect to the Northern Territory, and again, nothing that I have said today is intended to diverge from the central proposition, which is that competence or merit should be the sole criterion. So I think there need to be suitably qualified practitioners available to be appointed. That's the whole point of Magna Carta that I referred to. But as I say, I don't accept that there are no suitable practitioners in Western Australia or South Australia or Tasmania. I'm not sure there's much of a profession in the Northern Territory, but perhaps.
Can you please thank Xavier Boffa? I'm going to do just a very quick wrap-up. So we've heard from Amanda Stoker a paper which presents Justice Callanan's dissent in the work choices decision as an embryonic form of Australian originalism as a principle for constitutional interpretation. Many of you will remember Justice Thapar's visit to Australia last year, who is one of the chief proponents of originalism in the United States. Now, originalism as a constitutional principle of interpretation looks to the original intent of those who drafted the Constitution as being a guide to interpretation. It acts as a brake, therefore, on judicial activism. And it also acts as a brake on the centralisation of political power in a federal system of government. Amanda pointed out also to the unique quality of the Australian Constitution, which is a constitution that was approved by all of the people of Australia at a referendum and can only be changed by the people of Australia at a referendum, which particularly makes it a very democratic and non-elite constitution in international comparative terms. We've just heard from Xavier speak about the importance of the people that we select as the judges to our High Court. He reminds us of some of the problems that have happened when there are so-called independent selection committees, as happens in the United States, and the atrocities that have occurred with Robert Borg, Clarence Thomas and Brett Kavanaugh, to name just a few, and the politicisation of having a more transparent system of appointing our judges. And of course, there was a very interesting discussion on federal diversity in terms of our High Court appointments. I think you'll all agree that that's been a great start to this year's conference. Can I ask you all to return in a timely fashion for the Sir Harry Gibbs oration, which will commence at 11:30 by Justice Simon Stewart. And for those of you who wish to become members of the Samuel Griffiths Friends of the Wallabies, arrangements have been made to show the game tonight, so you don't need to find alternate arrangements. and go you good things. Enjoy the break, and we'll see you back at 11:30.